to, let's start with Akilah versus Benjamin Hughes because it's the easiest one to deal with. The update in that is that Akilah Hughes, after having had her copyright claim against Sargon of Akkad thrown out, was recently ordered to pay the legal fees, Sargon's legal fees, which in the order of $38,000. As far as I'm concerned, and in my limited knowledge of American copyright law, it seemed to be a very well-justified, well-reasoned decision that addressed all of her arguments and sort of systematically rebutted them one by one. She had said that, he raised money on GoFundMe, so he's not out of pocket. They said that that's irrelevant. Ordering her to pay the legal fees would further the intent of the Copyright Act, et cetera, et cetera. I mean, on the judgment itself, do you have any major disagreement, or is it a no-brainer?
It was a complete no-brainer, and she got very lucky that the fees were as low as they were. So normally someone would have, for litigating that, would have been a $75,000 to $100,000 kind of fee award they would have requested in New York. And she was given multiple opportunities to withdraw the complaint without having to pay fees, refused to. It was a patently frivolous lawsuit. Frivolous both under the copyright laws, in my view, frivolous, period. That's why her first lawyer jumped ship, who, by the way, she then attacked on Twitter.
Yeah, we're going to get to that.
For folks out there, I'm looking at trying to bring ways to stop this copyright abuse, which is taking place. There's two forms of it. One form is legal, one form is not legal. The legal form that's taking place is people are being targeted for political purposes, in my view, misappropriating the copyright laws to target the Alex Joneses of the world for suit. For every single Breitbart's been targeted in the same way. They're facing disproportionate number of suits from what they call copyright trolls in the business. Now, those suits are legitimate suits, but what they're doing is they're seeking 10 to 100 times the value that they would normally get for whatever the copyright infringement was. And so I did a bunch of these cases for Jones. We ended up getting good settlements in all of them. Pepe dismissals and some others. In the Pepe case, they ended up getting $13,000, for which they estimate they spent about $1 million worth of legal fees. They volunteered the legal services, but still doesn't change the fact that they wasted $1 million trying to collect 13 grand. But there's a lot of these cases where the copyright laws have been abused. And her case was classic because her complaint alleged something that by its own statement, and the judge pointed this out right away, did not constitute a violation of copyright law. For folks out there, the point of copyright law is to protect the inventiveness of ideas and creativity of ideas. And in that context, it also wants to protect people who want to criticize something, being creative in that process, being informed in that process, being inventive in that process. So it's called fair use doctrine, which means, so if someone's stealing your copyright to profit off of it, that's problematic. When, by contrast, when somebody's using your copyright to comment on it, they are creating, in my view, their own form of a copyright. And in some contexts, actually, it's recognized as such. And so what's been happening is people have been filing suits. So a lot of people get YouTube strikes for completely bogus grounds because the big tech is conspiring with big media to use algorithms to target any. I used it as an experiment on I have a small web page, YouTube page. And I do it often just to see how YouTube is handling different things. And YouTube actually issued me it wasn't up to a copyright strike. It was a copyright notice. And it was a copyright notice for using Vice footage that I didn't use. I just verbally referenced it. But that told me, okay, their algorithms are verbal, not visual. So so I was like, okay, from now on, I'll just say, look at this interesting something from somewhere, But that's all protected under fair use. So they're completely and in fact, there's a legal provision that allows you to sue when someone's abusing copyright law. It just hasn't been enforced a lot. And I'm looking into that because I think there's been a lot of abuse by copyright holders against people that are actually not violating the copyright laws. Hers was just a more egregious case. She knew this from day one. She was told this by Carl Benjamin, popularly known as Sargon of Akkad. And she still filed suit. The lawyer told her this was going to happen. She still went forward with the suit. Then the judge told her this was going to happen. She still went forward with the suit. And then the fee request was made. And instead of settling the fees, she probably could have settled 30 grand, gone home. She contested the fees, which, by the way, will entitle them to more fees for having to fight over fees. And if she appeals even more, the judge who was presiding over the case is a circuit judge sitting by designation. So some people might have been confused by seeing a district court issue a decision by a circuit judge. It's because sometimes our district court judges will sometimes sit on the circuit by designation, and sometimes circuit court judges will sit on the district by designation. One of the only places they cannot do that is en banc decisions, which we'll get to later, involving another case. So so it was an easy win. No chance of her getting reversed on appeal. High chance of her getting more fees assessed against her. Her argument that he got money elsewhere doesn't matter. This is like insurance cases. So like when you're in a personal injury accident and your insurance pays your medical bills, the defendant doesn't get the benefit of that. You get the benefit of that. So often, like in a personal injury case, there's a typical ratio for people out there wondering. It's usually 2 times your medical bills in the United States. So if you have an accident, the other side is responsible. Let's say you have $12,000 in medical bills, but let's say you only really paid like $500 co-deductible or whatever out of it. You get the whole $12,000. And then usually you get $24,000 for pain and suffering. Ends up being $36,000. A third of that typically goes back to the lawyer, 24, some legal fees. But basically, you get back the benefit of the medical bills even when you didn't pay those medical bills. It's the same principle. The fact there's a third party beneficiary has nothing to do with whether or not she's responsible for legal fees for filing what was frankly one of the most frivolous copyright suits I've seen.
Well, so now here I disagreed with this at the very beginning. In principle, is that I didn't think it was so frivolous on its face in terms of a copyright claim, because for anybody who hadn't seen the video, her original video was called "We Thought She Would Win." It was, I don't know, say a 12 or 15-minute video. Sargon's video didn't add, modify in the technical sense. It didn't caption. It didn't like meme. It was just sort of certain cuts conveniently placed, conveniently made that restructured the original video into a shorter video, 7 minutes. So. Or not, maybe 9 minutes. But it was a long video that did not transform in any physical sense. It didn't transform in the cartoonish sense. He didn't audio over. He didn't make any verbal commentary. It just re-edited the video and called it SJW levels of awareness, where it was the original video, original bits, and it was just clear what the commentary was.
Right.
So I think
that's the key part.
Yeah, well, that's it. So what ended up happening?
And
she
the
filed
second key part is she was dumb enough to say that in her lawsuit.
Okay, that's where it's different. Now, if that had been the only issue, I could say
if she would have said, "Hey, Sargon's trying to take credit for my genius," and is crediting it, then it would have been different. But instead, the whole lawsuit was, "Oh my God, he's making fun of me," and that's why the judge was like, "That's exactly what fair use is about."
The judge said 2 things in the original decision was, you admitted that he was mocking and demeaning you. That is commentary. And besides, you're not, one of the criteria, you're not targeting the same audience. It's not like he's stealing any money.
He's not trying to pretend he's you for purposes of stealing something unique you created. If she had alleged that, it would have been very different. She would have survived the motion to dismiss. She wouldn't have survived summary judgment because of what happened, but she would have survived the motion to dismiss. The problem was, as soon as she put in there that the reason why she was suing was because she said, "This is mocking me."
Yeah.
Well, that's commentary, fair use, classic version.
So she literally said mocked and demeaning. Then the judge says, "Look, that's quintessential fair use." In some pre-trial hearing, she pursues, makes a settlement offer after the judge says you've got no case. Her settlement offer was for $48,000, which was like, how you even think you're entitled to that, even if it were bona fide copyright infringement.
Correct.
And so that's it. So the judge came down hard. Now, the judgment was very well drafted. A lot of people were asking, if she appeals and fails in her appeal, those legal fees get added on, so she has some sort of incentive not to pursue an appeal.
Yeah, no doubt about it. Plus, when you have a circuit judge sitting by designation, I mean, every circuit judge knows this other circuit judge. It's just not, your chances are nil. I mean, so apparently she's looking for lawyer number 3, because apparently she can lawyer number 2. Now she's interested in lawyer number 3, decided to libel Sargon of Akkad in the same tweet thread, while she, of course, attacked the judge. Now, I personally, I have a different take on that. I'm for more criticism of judges. I got family that sit on the bench. I got close friends that sit on the bench, and I've told them this the same. And they don't mind. They actually share my sentiments for the most part. But that we have too little criticism of judges. So I'm not as critical of parties who are critical of judges, because I think judges need to be subject to more criticism. Now, it is often not the best legal strategy to pursue. But she hasn't shown any signs that she has any interest in that anyway.
Did as a circuit judge, is Sullivan, and it's a Sullivan is the judge, not, wait a minute, is this Judge Sullivan?
I think
as
it's
well, right?
Anderson or something like that.
Okay, well, whatever his judge's name is, as a circuit judge, is he elected or is he appointed?
Everybody's appointed because they're all federal. So
Okay.
this is the federal Second Circuit judge sitting by designation in the Southern District of New York.
So when she takes to Twitter afterwards, says, know your judge, posts, I don't think it was confidential or personal information, but, know your judge, and says something like, and get out there and vote so that more judges like this don't get elected to the bench. This judge was not even elected in the first place. It's not like he's subject to a vote for re-election.
Yeah, it's only appointment. So now you can't influence, obviously, judicial appointments through elections since the Senate has to consent to their appointment and the president nominates them in the first instance. And this was a George W. Bush appointee, I believe. And so but yeah, it's the problem was she clearly doesn't even understand the law still. I mean, she was trying to say, oh, they got confused. I was really trying to bring a copyright claim, not a harassment claim. I was like, yes, they understood that. That's what you didn't get. That's why you lost. The incapacity to understand basic logic is really rather sad.
The irony, and a lot of people were commenting on this, is that the reaction illustrates the exact intent and purpose of Sargon's video in the first place, which was there's no level of awareness. There's no level of reflection, stepping back and just trying to understand. She loses at every stage, which in justified in law, justified in fact. And after getting smashed for what she did on Twitter in the interim, after she loses, goes right to Twitter. I agree. She, I don't know if you call someone, the WS word or the white supremacist. I don't know if that's slander.
What it is she makes very specific statements about what happened to him vis-a-vis his election campaign. So the white supremacist, she might be able to get away with, that's still right now, that's hard to sue on in the United States. That might start to change. We'll see. But it's specific statement she makes about what happened to him in the election campaign that when I looked at it and saw Count Dankula and other people's interpretations, and from my recollection, it's not true what she's saying about him. And that was more factual statements. So I mean, I don't think I responded to her. I think he's put out a general tweet just saying, by the way, if you lose a lawsuit for filing one frivolous suit, you probably shouldn't libel the person who just won against you. But, take and not only that, for all of this hassle, she's out 50, 60 grand at least in her own fees, plus these fees. And she made Sargon, Carl Benjamin, $100,000 plus richer. So, congratulations.
And not just that, but now she's seemingly trying to crowdfund for her fees. And part of me questions whether or not she knows that it's all, a correct decision, but trick enough people to flip, to donate money to you and you can sort of fund your bill. I want to bring up one comment because, first of all, I love the comment. Paul Greenleaf says, you are both patriots for your work, even the Canadian. First of all, thank you.
That's funny.
But what I love about this color matches what you are wearing, Robert, in a way that is almost planned.
That's true. Yeah, exactly.
And if anybody's listening on the podcast, it's beautiful white, orange, and beige, or whatever color that is. So now, this brings us back to the original question. The original question was, well, someone asked me, what's your advice on taking your legal battles to social media in terms of public statements? Like, I say never do it. I know that's sort of the extremist because there are exceptions and there are times where it will help. What's your position? What's your advice on that?
I generally, it depends on whether the case is one where the court of public opinion is important. So if the court of public opinion is important, then you need to defend yourself in the court of public opinion, though you're better off generally if it's not you yourself having to do so. So if it's somebody else doing it on your behalf, it should be your lawyer, a good skilled lawyer defending you in the court of public opinion. Then you can retweet it and so on and so forth. But sometimes you have to fight your battle in the court of public opinion. The Roger Stone case being a paramount example of that. General Flynn, which we'll talk about, being another example of that. Alex Jones has to defend himself. He at least has to have someone do it on his behalf in the court of public opinion. I was recently on a PBS Frontline piece, which 98% of it was a hit piece. They did allow me to say two nice things. That was about it. In that kind of context, you need some sort of counterpoint. You need some sort of counterpunch. You need somebody to know that there's another side of the story out there. So I think, and this was all about a PR case on both sides. So I think in this context, defending yourself, arguing in the court of public opinion is just fine. You're better off, though, if it's someone other than you personally, ideally, doing so. That a good lawyer will be a very effective advocate for you in a court of public opinion, because what they say in the court of public opinion cannot hurt you in a court of law for the most part. In other words, it can't be used against you as factual testimonial evidence, for example. And at the same, in the way this was used against her, but in the same context, they often are just better at it. Particularly if they're skilled at it, they're more familiar with the media than most people are. Roger Stone probably being an exception, but other people being better at interacting with the media, and in particular knowing how the media and the law interface. So knowing what to say, how to say it, where to say it, when to say it. Like there is a time to bring questions about judges, but there's a way to do so. After you lose at the very end and whine, that doesn't sound persuasive at all. On the other hand, like in Roger Stone's case, my advice to him and others had been to point out, I would have moved to disqualify right away on grounds that they had manipulated the judge's selection and that the judge had shown overt bias in ways that suggest an impossibility to be impartial. Because that's what's going to happen, so you just get ahead of the curve. Here, this judge would have been happy to rule in her favor if she had any quality copyright claim. This judge wasn't biased against her politically or personally. It was because the judge he kept warning over and over. There are a lot of other judges who would have been much harsher with her, who would have issued sanctions for frivolousness and other things. He didn't do any of that. So he could have given signals that he would go higher in the fees. There's grounds to do a lodestar amount where you multiply the effect. He did none of that. He kept telling her, by what you're describing is not a copyright violation under United States copyright law. And she just ignored it. And the way we can fairly infer that she ignored it is she had to keep flipping lawyers. So that meant lawyers were saying, no. Now, anybody can make this kind of legal mistake. James O'Keefe won't get into the details of the NRA, that part of the gun rights suit. But his lawyer filed a suit in federal court against the FBI in the United States of America, in which he alleged a 1983 violation. Well, I understand people occasionally get confused on this, but not usually a lawyer who files suit in the Southern District of New York, or in this case, the Northern. Well, no, yeah, that one's the Southern. The NRA is the Northern. But the 42 USC 1983, while it's a federal law, it only applies to state, local, city, county governments. It does not apply to the federal government, and almost anyone would know this. And so I thought that was kind of bad, because usually O'Keefe has really good lawyers. James O'Keefe, Project Veritas, for people wondering who that is. He appears to have been wrongfully denied access to purchase a weapon because he's been wrongfully placed on the do not sell list by someone who lied and said that he had a felony conviction when he never has. He had a minor misdemeanor conviction for ambushing a senator inside a federal building, and he was undercover, so he didn't tell people while he was there. Only such prosecution I've ever heard of, purely politically motivated prosecution. A lot of misconduct in that case. But either way, for everybody out there, civil rights laws only apply to the states. The way you sue the federal government is by a specific federal statute that waives sovereign immunity, or you allege a constitutional claim, which is called a Bivens claim, after the case of the same name, Bivens versus 6 unnamed agents, that was decided by the U.S. Supreme Court, that said you had a right to bring that claim. But notably, in the Bivens case, you do not get your legal fees back. So the main incentive for lawyers to bring federal civil rights claims is that the legal fees can be recovered, so they can do it pro bono up front and just and if they win, recover. I'm currently in a fee battle in Virginia over a case that I won. But in the Bivens case context, there is no such award. But it was unfortunate to see that kind of mistake. So people make those mistakes on both sides. But here, she was warned repeatedly. She was warned by Sargon. She was warned by the opposing lawyer. She was warned by the judge. She was likely warned by her own lawyer. And she just marched right on.
Well, the thing is, it was the judicial admission that it was mocking and demeaning, which I presume even if she tried to redact that or amend it out of the proceedings, no one would ever let that come out of the proceedings. If the argument had been he used 7 minutes of a 15-minute video, he didn't need to use that much to make his point. He could have made it, he is profiting off my work not by passing it off as his own, but rather by using more than he has to of the original, so nobody has to go watch the original now. Those are the arguments I would have made. But that would have been a stretch. I mean, really what copyright's about is when somebody steals the credit for my invention rather than uses my invention to create one of their own. And even though he was using solely her words to create it, that's often done in the video context. Is using somebody else's words to indict them. When it's like that any good copyright lawyer would have told her, you don't have a claim here.
And I didn't recognize the name of any of the lawyers who worked on her case. And I know a fair number of the people in New York on the copyright context. So that told me that she probably went shopping. And my guess is a bunch of lawyers told her she had no claim until she found a lawyer who could take the bait, who thought, oh, it'll be a big political case, and didn't know what copyright law worked, and thought copyright is just, hey, whatever I create, no one else can. It's like those people that are suing Carpe Donktum for making a meme of that image of those two kids. And like their Twitter and false copyright claim, in my view, had led to him being off of Twitter. So I think there's got to be some way to combine those into a legal claim somewhere, but I got to figure that out. But but in that context, it's just sort of that's exactly what fair use is for. Copyright law was never meant to be like people sometimes confuse copyrights with patents. Because like a patent, you can't use at all, any part of, without certain kinds of permission. That's not the way copyright law is. Copyright is to protect creativity and inventiveness. And if that creativity and inventiveness is applied to use your original idea to create a new idea, that's totally protected, because we want to protect creativity. What we're protecting is not your invention. We're protecting the actions of creativity and independence of thought in the first place, and inventiveness of ideas in the first place. That's why anything that can be called commentary will almost always be exempt from copyright law, with the exception sometimes of a photo. So if you use a photo and it's not really part of the commentary, it's part of something else, then it's harder. That's where they're most protected. That's why photographers have become the biggest copyright trolls in the country now, because they used to get like, say, $100 for a licensing. And now they realize, hey, I can get a lawyer to sue and get 10 grand. And the lawyer claims statutory violations for which they can get $150,000 per time the photo was used. Now, I think that part of the law is going to change in its interpretation over time, but that's the full context of copyright law. But this is in my view, a classic case of total abuse of the copyright law by someone who knew better, or at least had been told better by people in legal authority repeatedly, and marched forward anyway. And she should be thanking her lucky stars. The legal fee was only $38,000.
Yeah, that's one of the things I said. I think Sargon's lawyers, now reading the judgment, appreciate they could have asked for more, but better off.
A lot more.
So STF-UFS said, is there any criminal remedy for Akilah refusing to contain herself? It seems she does not have the sense of God gave a turnip. She's libeling everyone now. So
in the old days, there used to be criminal copyright and criminal abuse of copyright and criminal libel laws. Even you could charge someone criminally for libel. Mostly not today. So I don't see any crime that she's committed that someone could charge a crime as at this point. Copyright abuse, if done in a certain way, can become a crime. But that's more like when you steal a copyright and do it 100 times. They haven't applied it in reverse when someone abuses a claim of a copyright. So at this juncture, I don't see any criminal charges, and it will never happen in Southern District of New York anyway. She could have committed 20 crimes. They're not going to care. It's a political filter they have up there. Worst criminal prosecutorial office in America, Southern District of New York.
All right. And I guess to end the question as to when you take your battles to Twitter, I'm thinking it sounds like the rule I would apply would be like the Simpsons rule when Krusty the Clown was gambling and his accountant says gambling is the best thing you can do if you know how to do it. I guess this is, if you know how to manipulate, use social media, do it. But if you draft something, it can sink a ship quickly, as was her tweets about, wanting to bankrupt Sargon, because that's.
She thought she was on the cancel culture bandwagon. She was the cheerleader. She was the lead conductor on the train. But when it backfires this badly, I wouldn't keep bragging about it. But she is.
Okay, now SJW levels of awareness was only 1 minute and 58 seconds. Facts matter. Love your weekend live streams with Robert.
Yeah, but that doesn't matter for commentary. You could actually put nothing on there at all, and it's commentary. So the question is, what is the purpose of it? So they don't want to discourage someone from creative commentary. So the creative commentary could just be to play it, and he could make a statement different than the statement that she originally intended, or even be her statement. That's all fair use. It's not fair use when you're trying to steal credit for. If this was someone pretending to be her and put up a fake YouTube page of claiming to be her and try to get super chat money related to it, that's what copyright law is about. It's not like patent law at all. It protects a different set of policies, and because of that, it's interpreted very, very differently than patent law.
Okay, now I'm looking it up. The original video was 9 minutes and 51 seconds, and it had a interesting choice of thumbnail. And it was 1 minute and 59 seconds. The SJW levels of awareness. Okay, and thank you very much, by the way, MetaZone. So that's it. It's phenomenal. It's interesting. Now, the judge he's like officially off the file. He can't come in and revise his judgment to up any award. If she appeals, it would only be an appeals judge that could change that?
No, the appeals court could do that, but the appeals court could reverse and remand back to the district court, and then it would go back to him.
Okay.
I guarantee you every lawyer is telling her not to file the appeal. Unless there's a lawyer that thinks she's got 50 grand sitting there to give them, they may say, sure, I'll take it. You know, and whether you lose is your problem. But this is a borderline frivolous appeal at this juncture.